Welcome back from the break. Our next panel is Financial Firms in the SEC's Crosshairs, Key Developments for Asset Managers, Broker-Dealers, Private Funds, and Hedge Funds. So with us today, we have Peter Altman, a partner at Akin, where he's the leader in the firm's digital assets, currency, and blockchain practice. Peter also sits on the firm's Partnership Admissions Committee and is the chair of the LA Office Hiring Committee. Peter previously served in the SEC's Division of Enforcement in Los Angeles and is a member of the division's Market Abuse System. Hardy Callcott is our moderator. Thank you, Hardy. He's a partner at Sidley Austin in their San Francisco office and a member of the Global Securities Enforcement and Regulatory Practice. He served in the SEC's Office of the General Counsel as an Assistant General Counsel for Market Regulation, which is now Trading and Markets, as we all know. And he taught in the Securities LLM program at Georgetown University Law Center. Jennifer Hull is the managing director at Berkeley Research Group. She's a certified public accountant and is accredited in business valuation by the American Institute of Certified Public Accountants. Laura Lynn serves as the chief legal officer at Wealthfront. Prior to Wealthfront, she was the general counsel and head of compliance of FNY Capital Management. And last but not least, Jeremy Pendrey is an assistant regional director in the SEC San Francisco office in the asset management unit. Thank you for starting us off on this great panel.
Okay, so as Jordan mentioned on a previous panel, we're all contractually obligated to discuss the Panawat case. So, Peter, let me start with you. If you run a fund that trades medical companies and an investment banker calls you and says, I want to bring you over the wall on Medivate, are you therefore banned from trading all medical companies for the length of the time that you're over the wall on the one company?
I certainly hope not. And so Panawat, obviously there's been a lot of discussion on it today, and we are not going to retread any of the ground, but we are going to explore a little bit of what Hardy was just getting at, which is something that the director talked about in his remarks at the lunch hour, which is investment advisors' standalone statutory obligation under 204 Cap A to have policies and procedures in place designed to prevent the misuse of MNPI. And so it's an important issue, and it's actually one. I went back and looked at this because I remembered when Panawat, when the trial verdict came out, I was like, I think I've seen an exam request where an examiner asked like a shadow trading style question. And what it actually was a 2022 risk alert that the Division of Examinations put out a couple months after the Panawat motion to dismiss decision was handed down in the SEC's favor, where there were actually deficiencies noted by the division in other exams that it had been doing in the context of expert networks. This is sort of similar to what you're getting at, Hardy, where the division identified shortcomings because, and this is a quote, registrants were not reviewing relevant trading activity of supervised persons in the securities of publicly traded companies that are in similar industries as those discussed during the calls. So that's 2022. Right? And a lot has happened, a lot of oxygen has been spent, ink has been spilled, whatever you want to say about Panawat. And obviously, we heard the director and others today say this wasn't a novel case. I found it kind of interesting that the SEC moved in limine ahead of trial, kind of a smart trial tactic, actually. And the judge ruled in their favor that the defense couldn't argue that the case was highly unusual, unique, novel, unanticipated, unexpected, or brought without fair notice. That's quite a list. Now, I will say, in closing argument, there was a line from the SEC trial team that really did catch our eye, because a lot of people were talking about how this is a traditional misappropriation case, and somebody's taking MNPI that they got underneath a duty of confidentiality, and they misused it to trade for themselves. However, I'm still not exactly sure what the standard is and what the lesson is to learn from Panawat, because it sounds a little bit like sort of after the fact assessments of materiality and correlation of stock prices. So here's what the SEC argued in closing. The only explanation for why Insight's stock went up on August 22nd is that the announcement of Medivation's acquisition caused Insight's stock price to rise. So however similar or dissimilar the companies were, the relationship was close enough for news of Medivation's acquisition to lift Insight's stock price. Now, if you sort of just let that sink in for a second, that's sort of, there's plenty of evidence put forth at trial about how these were, somewhat similar companies and a niche industry and, this, that, and the other. But that's a very broad statement that essentially stock price correlation could be enough to drive an assessment of materiality. And if you have some duty floating around out there, maybe the SEC is going to look to bring a case. So that gets me, Hardy, to really your question, which is how do you actually go about now how practically dealing with this if you're an investment manager and you do go over the wall, maybe you get access to some data room, or you're brought over for some private placement, whatever it might be. How are you going to assess whether there's sufficient market connectivity between the company that you're getting MNPI on and other names that maybe you're out there looking at? We've had a lot of clients who've asked us, does this case mean the mosaic theory of research is dead, that we can't ever sort of use information that we learn in one place and apply it to our thesis for some other investment? And I just don't think that can be the case. I think that the facts of Panawat are so narrow at the end of the day that you're talking about a corporate insider, this the 7-minute gap, all of the facts, all the circumstantial evidence that came out still feels like a very narrow circumstance to me. And so the way that we've been trying to talk through situations like the one you described is to actually use Panawat as a tool for compliance and legal folks at firms, at investment managers, to go and engage with the research teams and talk about, well, why are you signing that confidentiality agreement? What are you really looking to do? Is it for a deal in that name? Are you thinking about it in the context of something else? Because the reality is, as I said, SEC's advanced data analytics, after the fact 2020 hindsight assessments of materiality, enterprising staff attorneys are going to be looking to bring cases. And so engaging with people on why they're signing confidentiality agreements, the language of the use provisions in confidentiality agreements that are on the data room click-throughs and other places where people are assuming that duty, that's the stuff that matters, if you ask me, is what is actually in that writing. Yeah. Do you have limitations on how you can use the information?
And so we have advised our clients, our funds clients, make clear in an NDA, you're only restricted with respect to the specific company. So Panawat had 3 different sources of duties. Well, if you're an investment fund manager, you're not an employee. You don't have a general employee fiduciary duty or officer fiduciary duty. You don't have a general confidentiality agreement. You only have the NDA. That's what restricts you from trading. And if that says you're only restricted in the specific name, our argument is, you go see something about Medivate and you see, and that informs you about another company. It's perfectly fine to trade that other company. Now, remains to be seen if the SEC will agree with that, but it is a very real issue, and it is not something that I think the SEC has addressed. And we're not going to ask Jeremy to express a hypothetical view on that one. So, again, we've heard some today already about off-channel communications, but let's focus in on the investment advisor issue. So there's been 60-some cases. Only one, Senvest, was against a standalone investment advisor. The investment advisor books and records requirements are actually very different from broker-dealers. Broker-dealers are required to keep all records relating to your business as such. Jeremy, how do you view off-channel communications in the investment advisor area? And I should say, Jeremy's in the asset management enforcement unit, so this is his particular area.
So thank you, Hardy. So first, let me start by doing our standard disclaimer. These are my views, nobody else's, not the commission's, no views of the other staff. So look, it's true that we've only brought one case so far against a standalone IA, but IAs have been part of this from the beginning. In the very first group of cases that were brought in September 2022, after there was the singular case before that, but the first larger group of cases, there was a case against Deutsche Bank, some Deutsche Bank entities that included IA charges. In later actions brought in August and September of 2023, there were also cases that included IA charges. And in February of 2024, there were 16 more firms, which included 4 IAs as well. So there have been IAs involved in the cases we've brought since the very beginning of this group of cases. So look, how do we view it differently? Look, you're right. The broker-dealer cases, pretty simple. You have to maintain all your communications relating to the business. But there are a number of categories in the IA space that fall under the statute, and it's fairly broad in its own way. For example, any recommendation, so these are documents you would have to maintain. Any recommendation made or proposed to be made, any advice given or proposed to be given, any receipt, disbursement, or delivery of funds or securities, placing or execution of any order to purchase or sell any security. And these are just a few examples. There are more categories of the types of documents you have to maintain. So while it's a different statute, it is a fairly broad statute in its own way. And in these cases, if you look at the orders involving the IA cases, we are specifying in those orders which categories of documents were found to have not been maintained. So the particular categories that I read are actually identified in the orders. In the Deutsche Bank order, I think it's the recommendations. In the Senvest order, which is the standalone case, more recently, I think it was 2 categories or 3 categories.
I think it's recommendations and trading.
And trading, that's what it was. Okay, so there's, we're not trying to, I think we're being fairly clear about what wasn't maintained in these cases where it involves IAs. And although it's a different calculus, it's one that I think is fairly broad, and we're being open about how we're getting there.
I will say, I think the Senvest order actually casts a bit of lack of clarity, and I'll just explain why, which is that, so this was a standalone IA, private fund advisor, and the press release for this case talked about the registrant committing record keeping and other violations, or having record keeping and other failures. I read this order the day it came out, I think 5 times, to try to really distill what actually happened and what the SEC really found. And I think the better way to have described the action in a press release was actually compliance violations and some other stuff. And what really happened in this case, as I read it, I think it was the 4th or 5th time where I figured it out, was that this registrant had a very broad policy. The way I wrote it down was it strictly prohibited its employees from using non-firm electronic communication services for any business purpose. Now, there are many investment advisors that have policies like that. There are many that don't, because as you all were just saying, the Advisors Act regime is different than the regime that's applicable to broker-dealers where they have to maintain all business-related communications. Senvest, for whatever reason, decided to have a broad policy. Now, the SEC found that in violation of that policy, again, a compliance policy, not a record-keeping requirement per se, that individuals, including senior executives there, sent thousands of business-related messages, thus in violation of the policy. Now, that also led into a supervision charge, given that there are senior people involved in doing this. But then buried in the order is the reference to numerous of those off-channel communications related to documents described in 204-2A7, which is what you were just alluding to, of the Advisors Act, that enumerates certain books and records that need to be kept. So I think the takeaway there is investment advisors have different obligations. Now, there may be good reasons that you want to keep all business records around, or all business communications around, I should say. But there may be reasons that you want to approach the world differently. And I think the thing that's difficult to digest about Senvest is that this is a company that had a policy and now is being sort of strung out a little bit, or strung up under the compliance rule, but it's being called a record-keeping case. I think that's actually kind of confusing for the market to fully understand like what the SEC was doing here. I think the other thing there's a couple of other interesting takeaways from that case in my view is the order pointed out that after engaging in off-channel communications, firm employees did not take steps basically to copy the messages over to firm captured systems. And I think that's notable because there are a lot of firms out there now that are setting up tools whereby if someone does send a stray text that does hit one of the books and enumerated books and records, they can forward it to like a compliance-related email address where it then does come within the firm's retained systems. And so I think firms are really trying to figure out how to scope their policies in light of this one and thinking about how do their personnel use, what devices are they using? Do they have particular needs where they need to be communicating over particular platforms in certain parts of the world? Like, here in the US, WhatsApp is popular, but in parts of the world, that's the only way people communicate. And I think technological solutions for capturing those types of messages, also in the context of private fund management, it's a little bit different than the way the books and records rule is written. So the point really is firms, I think, are trying to digest what they need to do. And then one last thing on Senvest, it's impossible to ignore the fact that there were references to violations with respect to personal trading approvals and also remediation in that topic area where the firm changed its policies and procedures associated with certain types of personal trading, like limiting the amount of options trades that employees could do each month. And I think what that really is a signal is that there was some substantive issue that was going on at that firm. And there was an investigation, the electronic communications point came up, and it sort of took on a life of its own. And that was the order that we got. But I think that the through line there is that in more substantive securities law investigations, the e-coms issues are going to just continue to be a prevalent issue for the staff to dig into.
And there's been press suggestion there could be a lot more investment advisor books and records off-channel comms cases in the next few months. Let's move on to the investment advisor marketing rule. So that rule has been in effect for about 18 months, at least for firms that didn't pre-adopt it. And there's already been a fair amount of enforcement activity on that. Jeremy, can you give us a overview?
So we've had 2 rounds of cases so far. There was an individual case as well, but thinking of the more broader sort of sweep type actions we've brought, there was a round in September of 2023 and then also in April 2024, so just last month. And these are firms that are advertising hypothetical performance on their websites without having policies and procedures to ensure that the performance shown is relevant to the likely financial situation and investment objectives of the intended audience. So if you hear what that standard, as you can imagine, if you are making claims on a website that's available to the general public, you're not going to be able to meet that standard. So these are what these cases are about. These firms they have hypothetical performance that's going out to anyone who looks at their website, and they don't have policies to limit it to folks who have particular needs and who have particular situations. 4 of the 5 firms in the most recent round, there were 5 firms charged in April. They got reduced penalties for taking corrective steps before the cases were filed. One of the firms, Geosphere, ended up paying more. They had a number of other advertising problems, not being able to substantiate performance and having false and misleading ads, so beyond just the hypothetical performance issue. So again, I think the bottom line here is that firms have to be really aware of the fact that they can't just put out any hypothetical performance they want on a website that's available to the general public.
Okay. Jennifer, what have you been seeing in the hypothetical performance area? What are the issues that your clients are coming to you about?
Well, as you've heard, the hypothetical performance must be relevant to the audience, and it can't be false and misleading. So as an accountant, I think that the approach to work related to hypothetical performance needs to begin with a comprehensive understanding of the degree of estimation uncertainty that exists in the calculation. For example, low estimation uncertainty may exist if your hypothetical performance calculation is based on, say, 10 years of actual historical performance and was achieved in an industry that doesn't experience much volatility. In this scenario, your stress testing, your modeling, your adjustments to inputs and assumptions for interest rates and growth all resulted in a small range of possible outcomes. And then at the other end of the spectrum, high estimation uncertainty exists if hypothetical performance is achieved, or is derived, I should say, from 1 month of historical performance and is in an industry with volatile returns. In this scenario, your modeling and stress testing resulted in a large range of possible outcomes. So a policy that considers the placement of an estimate on this scale, I think, can guide the quantity and type of disclosures to include in your marketing materials. So with greater estimation uncertainty comes the need for greater explanatory language and risk disclosure about the estimate. For example, if the hypothetical performance is highly uncertain and was derived from a large range of possible outcomes, your disclosure may need to quantify and include a description of the large range of possible outcomes and also include an explanation for how management selected a point estimate within that range. So overall, I think, if you start with this thorough evaluation of, measuring the uncertainty, it serves three purposes. One, it can guide improvements to your policies and procedures. Two, it can guide the quantity and type of disclosures in the advertisements. And three, while it's difficult to predict how regulators or investors will respond to uncertainty, a comprehensive assessment of it will guide and support a firm's response to the questions about the estimate.
So Lauren, you've been living with the marketing rule now for more than 18 months. I think you pre-adopted the rule.
Yep.
How has it worked in practice for Wealthfront?
So it's interesting on the hypothetical performance issue. I mean, we know that the SEC didn't prohibit hypothetical performance to a mass audience, and what that means in practice is sort of what we're trying to figure out and what we're dealing with. I think we're unique in the sense that my CCO always jokes it's the get rich slow scheme. What we want people to do, what our investment philosophy is, and all of our education to our clients is to invest in this diversified portfolio of ETFs and build your financial future. Our white papers talk about how there's no secret. Don't try to time the market. Our products are very vanilla and conservative, and this is the advice that we're giving. And we're targeting sort of like this mass affluent group of clients. And maybe that advice is good for a lot of people, for a huge audience. And so trying to figure out how our policies and procedures support that and really what it means. I think we have a lot to learn from how the SEC wants to enforce hypothetical performance.
And I'll just observe there's some difference. SEC rolled out regulation best interest, 5 years ago, and really waited quite a while to bring substantive cases. The first round of exams resulted in deficiency letters, and people were able to, fix things that the exam staff perceived as deficiencies. Marketing rule has been different. Marketing rule has been going to enforcement much faster, and I think the anticipation has to be that will continue.
Yeah, I guess I would say that the rule has been in effect, as you said, for quite a while now. It's not a new rule anymore. I think some firms feel like when it's a new rule, there should be a sort of free pass if they get it wrong the first time. But I think this has been out there. It was passed in December 2020. There was a pretty long period of time to give firms to comply, and now it's been in effect for a while. I saw one law firm's report that said, quote, "The focus on hypothetical performance should not come as a surprise. That law firm was yours, I think, and that was an article that you wrote, I think. But
I haven't said anything in response to this question.
The opinions he expresses.
and you were citing some of Grabier's quotes that he was, publicly talking about.
Oh, it's all fair game.
Yeah.
Let's have at it.
So it was, this was stuff that I think we've been pretty open about the fact that we're going to enforce the rules, and we think that there's no reason to wait to do that.
So let's go to investment advisor custody. So there have been some changes in the custody rule, but it continues to be, before and after, it has been a focus for SEC enforcement. Jeremy, what do you have to tell us about custody rule?
Yeah, so
cases?
we've been definitely bringing cases involving private funds who are not following the custody rule, private fund managers who are not following the rule for their funds. So in September of 2023, we brought a case, or 5 separate cases against private fund advisors. They either have to have a qualified custodian and be subject to annual surprise exams, or have annual financial statements that are audited and timely delivered. So those 5 cases were penalties from $50,000 to $225,000, depending on the case. And that was a second wave. There was 9 firms. There were 9 firms charged the year before, in September of 2022. And I don't think there's any big surprise or new development here, other than it's a continued focus, and we think it's an important thing to be on the lookout for. Obviously, safeguarding client assets is a huge concern of ours, and so these cases, I think, are showing that that's something that we're continuing to be focused on. They did include charges involving not updating the Form ADV, kind of a technical point, but essentially, if you're filling out your Form ADV that's telling your clients that you are getting audits done or providing audits timely, and you're not doing that, that's a problem as well. And we included charges involving that kind of conduct in those cases.
Jennifer, what are you seeing in the custody area?
Well, under the audited financials alternative of the custody rule, financial statement audits must be completed and distributed to private fund investors within 120 days of fiscal year end. And so for that reason, as an accountant, I'm always alert and mindful of developments in the audit and accounting profession that could impact an advisor's ability to deliver audited financials in a timely manner. And although I don't think it shouldn't impact the timeliness of audits, a development in the audit and accounting world that is of interest to advisors is that critical audit matters, or they're CAMs, is what we call them for short. They may change both in terms of quantity and depth of disclosure. CAMs are not required for audits of broker-dealers or registered investment companies, but they are commonly encountered during audits of private funds. And for those that aren't familiar with CAMs, in the old days, audit reports used to just contain pass or fail language. A few years ago, the requirement to describe critical audit matters within the audit report. So on the first page, your investor opens it right away on the first page, pass or fail, and then this is a critical audit matter that us auditors had to spend a lot of extra time on, and there's a little description about it. CAMs have 2 characteristics. They relate to an account or disclosure that is material. And second, they involve especially challenging, subjective, or complex auditor judgment. For example, audit reports for many private funds include a CAM about challenging asset valuations or unusual or non-recurring transactions with related parties. And investor advocates have 2 broad criticisms. One, there aren't enough CAMs because the threshold to achieve it is too high. Specifically, the rule says that the account or disclosure must be, quote, especially challenging to be a CAM. The second criticism is this boilerplate language that started to appear in audit report after audit report. It was describing the audit procedures, but sometimes excluded a description of what the auditors found, which is apparently what the investors wanted to know. So as a result of the advocacy, critical audit matters was recently added to the PCAOB research agenda to study whether there is a need for guidance or changes to the standards or other regulatory action to improve the usefulness of information that is provided as part of the CAM reporting. So, there may be some increased communications this year with between advisors and auditors about critical audit matters.
So Jennifer mentioned valuation, and valuation has been an issue that the SEC looks at for investment advisors, especially for private funds. Peter, what are you seeing in the valuation area?
Yeah, I think just one observation, Hardy, and you're right. It's really a perennial issue going back like 15 years. I feel like it's been something people have been talking about. The observation is in some SEC exams that we've been involved in. We've seen some pretty sort of, I would say, resolute second guessing of decisions that were made by registrants on non-level 1 assets, like in the context of their business during the exam. And I think a lot of it's driven by the specific experience. All exams are driven by the specific experience of the lead examiner in our view, whether they're a lawyer or an accountant, an economist. Different experiences lead to different types of examinations. But valuation is one in particular where I've just seen, in order to get the staff comfortable with judgment-based decisions that are made on level 2 or level 3 assets in the course of doing business, the amount of work it's taken to get them comfortable has been sort of a newer thing for me to observe. And in a recent situation, we had to put in an expert report, like just essentially revaluing the assets, and while also kind of putting into context decisions that were made by the registrant, like, contemporaneously. And so, where that kind of leaves me is, while that's a resource-intensive process for a registrant to have to go through, I actually ultimately think it's a better thing to have to deal with that process in exam than have the case sort of have the examiners throw their hands up over the issue and send it to enforcement, which then is its own sort of resource explosion. And so that's just something we've sort of experienced a couple of times in the last year or so. And it'll be interesting to see if it continues.
Yeah. Jennifer, are you getting brought in on valuation issues and SEC exams and enforcement?
I can pretty much echo everything that Peter just said. I think one common level 3 valuation topic that I see over and over again is, policies and procedures. Advisors must adopt and implement reasonably designed written policies and procedures addressing the valuation of private fund portfolio investments, and level 3 investments come up again and again. Specifically, the procedures that address valuation in general terms might be criticized for not providing specific parameters as to how to value the level 3 investments. Instead, the policy should describe valuation techniques with some, specific techniques, and also should include procedures designed to promote consistency in the valuation process. And then a second common level 3 valuation topic concerns the depth of the disclosures provided to investors. Guidance and templates exist, but the quantity and quality of disclosures are still, like Peter said, subject to judgment, and that's where we run into dispute. So example disclosure decisions that require judgment include the level of asset disaggregation. Sometimes there's questions about whether to disclose inputs to inputs. Also, whether to disclose discussion about the models and the data that you considered but rejected. I think those are 3 examples of some disputes that come up. And I think that tests can be developed and used to benchmark or judge these disclosures. And the inputs to these hypothetical tests start with SEC rules and interpretations, but that's often not enough. And so some other guidance that can be plugged into this test can come from a firm's policies and procedures, if they're specific. Also, peer disclosures that you can obtain with the help of data subscription services. Guidance published by audit firms is useful to use, and also guidance published by industry associations. So at the end of this test building process, you have something populated with from numerous sources that can hopefully resolve the disclosure dispute.
So we're going to skip SEC cases against financial services firms on AI, because there's a whole panel on AI coming up next, but that's definitely an area we would otherwise have covered if there wasn't a separate panel. Let me ask a different question. Lauren, as inside counsel, in-house counsel, in a room full of SEC enforcement attorneys, what are the issues that you worry about?
Nothing. I have no concerns. Thank you. No. I think the first thing is that and it was talked about here today, we've worked really hard to establish an open relationship with our regulators, and that's the tack that we take. We want the information, we want to know where the guardrails are, because it's helpful for us, and it's helpful for us in having those conversations with our business partners so that they understand what the guardrails are. There are two things I have been thinking a bit about. One is sort of the challenge of communicating with our clients in a way that resonates with them. Our clients we're, for those of you who don't know, we're a robo-advisor, and we cater to wealthy millennials. And they are used to being pulled in a million different directions. We're trying to grab their attention, and we're trying to maintain our commitment to education and how does this product work, why this might be good for you, and how do we do that when people are, reading in sound bites, looking at their phone. We want to give them all of the necessary disclosures and disclaimers, but our information architecture philosophy is that we give information in increasing waves of granularity. How do you do that while still meeting all of the requirements of the rules to show people all of the information they need to know on page one? So that's something we think about all the time. It's something we work on all the time, meeting people where they are, and trying to get their attention in a way that educates them. I think the second thing that I'm thinking a lot about is sort of the future of AI and what that means for investment advisors. And I was talking about this earlier. I have seen some really interesting products. Obviously, people are coming in, doing demos. They want us to be interested. We're not using any yet, but I want to plan ahead. And products, including in RegTech, that are really, really interesting, that I think could be helpful to a human who wanted to use them. And thinking about how do we change our compliance program? What do we need to add? What enhancements do we need to make in order to be prepared for what is inevitably coming? Those are two things that I wouldn't say they keep me up at night or worry about, but 2 points of focus on the long list.
Yeah, and I will say that the layered disclosure point, in theory, the SEC and FINRA say they endorse layered disclosure. Sometimes in practice, they're not always as enthusiastic about it as you think they might be. So that is an issue that is, especially in environments like app-based, investing on, a phone or something, where there's very limited real estate. It's a real problem. So I know there's going to be another panel that is going to discuss SEC regulatory initiatives generally, for everybody in the securities industry, for everyone, subject to SEC rules. But specifically for financial services firms, there's a lot of rules out there that are in various, in the process of being proposed and adopted. I mean, Peter, do you have some thoughts about sort of the SEC regulatory agenda for financial services firms?
It's a long list, and it's just some observations. And this has been a topic at lots of conferences like this for the last few years. But just a few observations. So on the predictive analytics rule and the custody rule that were proposed, Chair Gensler just a couple days ago announced that those would be reconsidered in light of like a large amount of comments that had come in, and I think that's just generally a positive thing in administrative rulemaking, would be acknowledging that maybe you didn't get it right in your first proposed rule, and it's kind of juxtaposed, of course, by the fact that the SEC is in active litigation over a couple of its rules, the private funds rule, which is still set, obviously, to be effective, And then also the ESG rule, which the SEC itself, I think, paused implementation of pending legal challenges in the Eighth Circuit, a circuit we haven't heard about today. But just going back to the predictive analytics rule, and I know time has been spent on this, but just to kind of underscore the challenge of writing rules that kind of make sense for evolving technology. There was this concept that essentially the rule was going to have covered technology was going to be what was covered, and I think a lot of people thought that was really meant to be capturing predictive analytics, like artificial intelligence, things like that. But what it really turned out to include was like essentially anything, including like an Excel model. And so we were very glad to see the SEC, to see Gensler talk about rethinking the scope of that rule. And then the last thing, Hardy, just on the long list of rules was for anyone looking for just a little bit of levity in this whole very consequential suite of rules. I thought Commissioner Peirce penned a very interesting and pithy concurrence regarding the amendments to Reg SP, where she was quoting, as she often does, like pop culture references to like the old Mr. Postman song. And the point about how the new regulation was actually going to lead to more and more notices, in all likelihood, landing on your doorstep. A tie back to the song, and how will that actually be a good thing? That if you're getting more and more notices over some company having experienced a cyber intrusion, do you get to the point of just not reading any of them and then not doing anything about that? I thought that was a very interesting observation. It sort of left me thinking about how, like, we all, probably many of us, get emails all the time from service providers that have experienced cyber breaches, and at some level you're a little bit like, okay, like, what do I do about it? Like, probably not much. So just an interesting observation from her.
Yeah, and I'll just follow up to say, I mean, we've been waiting for, the Commission adopted a public company cybersecurity rule. It proposed cybersecurity rules for broker-dealers and investment advisors, hasn't adopted those yet, although I certainly expect they're going to come. But anybody who hasn't paid attention to the Reg SP rule that just was adopted earlier this week, there actually is a lot of stuff in there about cybersecurity, about having to have an incident response system. So some of the things I thought was going to be in an IABD cybersecurity rule actually is more or less in the Reg SP rule that just came out. So obviously, privacy is important, and the SEC brings cases about Reg SP, and I think everyone should take that one seriously. I'll also just observe, I think this coming weekend is when T+1 trading goes into effect, and that's actually a bigger deal than maybe people recognize it's going to be. So, I mean, trades, instead of settling after 2 days after trade date, they're going to settle the day after trade date, and that's a huge systems change for a lot of firms. It affects how you pay for securities trades, how margin is calculated. There's a lot of sort of knock-on effects. I think it's actually, if you're sitting in Europe and doing a trade, and at the end of the trade day in the United States, you actually can't get the money from there to here within one day because the banks are already closed in Europe. So anyway, we all think, or at least I think, that shortening the trade cycle does reduce risk. I mean, this is a result of the meme stock events from back in early 2021 that caused the T+2 trade cycle added a lot of risk into the security settlement process, but there are going to be bumps in the road, I absolutely guarantee you, on transition to T+1. And I think, I mean, just to sum up, we haven't even gotten into, investment advisor outsourcing, market structure, best execution. There's a whole set of rules that affect financial services firms. And what I hear from people at firms is it's not that any single one of them is impossible, other than the predictive data analytics one, which actually would have been impossible, and I'm happy that they're reproposing it. But it's the combined effect of all of them at the same time, with limited technical staffs that firms have. That's what's the real challenge. And I hope that people at the SEC are listening to that challenge.